Welcome, everyone, to our webinar today on the election recap. Before we get started, I want to do some housekeeping. First of all, Rule 14408, Utah State Bar MCLE rules requires that we submit the names for the people who spend the entire hour on the CLE. The rule says an hour of accredited CLE means 60 minutes of attendance in a 1 hour period at an accredited CLE. This is an accredited CLE, so you have to stay for the whole hour in order for us to submit your name. The second thing, as we go along, we'll have time at the end for question and answer. Please use the Q&A feature, not the chat feature, and we will try to get your questions answered as we go along. Now, it's my pleasure to introduce to you our two speakers, Tyler Green and Matt Sanderson, both who have extensive experience in this area and who have graciously consented, were bullied into speaking at this program today. So I'd like to welcome them and thank them for participating. Now, before we start, I had to get educated on this topic because I've never looked into this, and I think there's some background information that's kind of interesting. And it struck me, Tyler and Matt, that the Constitution gives power to state legislatures for this. So it's all state by state rules, which are different. Does that ever present any difficulties?
Maybe I'll take a crack, Matt, and you can add on. I don't know that I would call it difficulties necessarily, unless one of your thoughts is, or one of your goals is to try to figure out how to drive some sort of nationwide change. I mean, the reality, as you said, Lori, is that it's Article 1, Section 4 of the Constitution, the Elections Clause, does give state legislatures the primary authority to set the rules for the time, place, and manner of elections of representatives. Congress has the power to revise those laws. And of course, under the 10th Amendment, the states can set whatever rules they want for their own elections, as long as they're not inconsistent with other constitutional guarantees. But it does mean if you're unhappy, if you're a plaintiff group or an interest group that's unhappy with particular election rules, you do have to do a sort of state by state look at those and then figure out, rank them, prioritize them as you will to figure out which ones you want to go after first or in what order. Excuse me.
Yeah, I agree with that. So yeah, it's clearly designated to the states. And I know in my practice, advising media organizations or other entities that, financial institutions that kind of want to get a sense of what will happen in the election from a legal perspective, a lot of times the variation in state laws can very much seem like a bug, but it is a feature. It can be frustrating to understand the niceties of various states' laws, even when you're narrowing it down from 51 state level jurisdictions, so the 50 states plus DC, and then narrowing it down to just the swing states, down to about 10 swing states. There's still a lot of variety in the rules and the approaches that really could affect the election and how it's administered. But I think on the other hand, I think this election cycle, this post-election period more than anything, has shown the wisdom in designating the states for being primarily responsible for election administration, because state level officials have been less likely to buckle under pressure than I think a national election official might have been. If there was one single czar over all elections, I think that could have been problematic and might have been problematic in prior elections to now. So I think our distributed system is actually a good thing.
Oh, okay.
Even within that, sorry, Lori, if I could just give one follow-up to Matt's point about different approaches at different states, even in swing states. Some states even go a step further and diffuse power, somewhere else besides the legislature. Wisconsin, for example, right, has a nonpartisan election commission, statewide election commission, and then they even go down further and put things at the county level. So if you were someone or group or whatever that had an interest in trying to do something litigation related in Wisconsin over election laws, there's really a menu of options you have to sort through to figure out who's the right defendant, what do I want to, what type of claim do I want to bring, and how do you get everybody named so that you've got the right parties involved in the suit.
Okay. Well, this election season presented, speaking of different laws in different jurisdictions, presented a new wrinkle because of the coronavirus pandemic, where states as they treated the pandemic, had vastly different approaches to isolation, stay at home, all kinds of things. So did that add another layer because of the different way they approached the pandemic, combined with the different way they may approach an election?
Yeah, I think that's certainly the case, and depending on how you count, my count is something like 44 states made significant changes this year to their election administration procedures in recognition of COVID. And anytime you move the rules around, there's going to be litigation. There's going to be some element of confusion, particularly if administrators, election officials are dealing with a set of rules for the first time. You can put it down as detailed as you want in paper, but until you actually get a ballot and have to process it, tabulate it, and then store the vote and do a recount, et cetera, go through that entire process, there are little logistical issues that present themselves. So I think certainly COVID had a lot to do with it, but election administrators were really dealing with a lot this cycle. You have not only COVID, but you have a real uptick in election turnout. So you go from about 140 million votes nationwide cast for president in 2016 to about 160 million cast this time. And then you also have not only a larger pool of voters, but because of COVID and because of kind of long-term trends, you have more and more voters deciding to shift the casting of their vote before Election Day, either in-person early voting or vote by mail. And so there are a lot of different things to deal with, and that drove a lot of complication, I think, drove a lot of litigation. You have 400 some odd cases that were litigated before Election Day, which is a drastic uptick in what the norm is. But I think, it's certainly the case that COVID drove a lot of that.
Yeah,
So,
and the question, sorry, Laura, to interrupt you.
No, go ahead. Go ahead.
To Matt's point about, the rules, the important question always in a lot of these cases or issues is, who is the one deciding what the rules should be? We talked earlier about the Constitution vesting state legislatures with that power. Okay, that's one thing, that's fine. That's what the charter says. So you get in a situation really unprecedented in our lifetimes, like the coronavirus pandemic, and suddenly you've got governors who are trying to do what they're supposed to do to help, manage the state, make sure it's running well, do what they can. In a lot of states, the legislatures gave emergency power declarations to the governor. Those were existing in statutes that predated the coronavirus pandemic, but they weren't necessarily targeting something like a pandemic. It was something more along the lines of Louisiana or Florida. If they had an election coming during hurricane season, there's a Category 4 hurricane barreling toward them or something on Election Day. What do we do, right? Our voting, we have to figure out what to do about voting centers and how long the polls are going to be open, those types of questions. The sort of more traditional, but before now, I think the executive branch in a lot of states had thought of as the traditional emergency situation. You've got a set of emergency powers that governors can do something with in those circumstances, figuring out how those sort of delegations of power, to the extent they existed, would apply in this situation where it wasn't an acute, one time, one day issue, or maybe a couple of days issue, but was rather a months-long problem. Because you remember, this issue started, the pandemic obviously was sort of a mid-March when things kind of really all hit the fan, and the Jazz game was canceled in Oklahoma City, right? And then it was sort of one domino after another after that. That's, you think about it, in one sense, that's 8 months away from Election Day in November. Okay, fine. But don't forget, before that, we've got months of buildup of primary elections or caucuses or different things happening along the way. So these are issues that need attention right now. The governors had to deal with right then, but it's over the emergency that precipitated it was over a very long period of time. So I think that's one thing, that came up. I know we litigated it some, and it's one thing I know that some state legislatures are taking a look at in this go around this 2021 cycle for the legislative sessions to figure out, okay, what do we do about stuff like this, if it happens again?
Well, and that is my question, because the pandemic did start in March. Were the rules changes started, did they start then? Or did they make rule changes at the very end, right before the election in November?
I think, I'm curious to hear what Matt says and what he saw. We saw some of both. It's a question in some circumstances, right? You've got people who are bringing lawsuits. And so you've got a court or a judge someplace as a decision maker, whether it's a district judge or you take it up the line to an appellate court or the Supreme Court. You've got a judgment from a court that says, okay, here's what, you've got to do to make whatever your system is compliant with what I think the Constitution requires. So you've got some changes that happen that way. Some things got stayed and they went up to the circuit court, or even some to the United States Supreme Court got stayed. So you had initially, a rule change that then was back off, and we did it the old way, right? That happened in a couple of states. You had some governors who said, we're going to make some changes and then tried to do some things by executive order. In some states, the legislatures passed laws ratifying those changes. In other states, the legislatures got mad and sued their governors and said, no, this is our power, and we're trying to be protective of, their authority. And in some cases, right, that happened, sort of one set in the primary election phase, worked through all of those in the springtime and summertime. And then by the time we got to the fall and people realized this pandemic wasn't going away anytime soon, legislatures acted and took the initiative and passed laws to try to help accommodate the reality of the situation on the ground. So we kind of saw it all over the map, but I don't know if Matt, if you had other impressions.
No, I think that's exactly right. It was a dynamic situation in terms of the changes because as Tyler mentioned, either legislatures or executive branch officials were making adjustments to their regulatory regime, and then that would result in litigation. And then you have litigation, some sort of settlement or some sort of ruling that may take some time, and then a second wave of that with the general election. And sometimes executive branch officials or the legislatures would wait until well before or just before the general election. And in other cases, litigants didn't appear until the general election. So for example, South Carolina, there were, with its voter ID and verification for vote by mail, for example, rules had existed, they had been in place, and everyone had kind of acquiesced in those. And then in the general election, there was some litigation related to that. So very dynamic situation, hard to follow at times. It is a full-time job, could be more than a full-time job just to follow all those cases. Whenever you're talking about 400 plus unique pieces of litigation, it's a very dynamic situation.
And some of those too, I mean, to Matt's point about like coming close to the election, there was one case we saw in Arizona. There was a lawsuit filed, sort of like 5 days before the registration deadline was supposed to end. Right? Arizona's got a law where you've got to register so many days before the election. I can't remember if it's 21 days. There's some period of time, like 5 days before that was supposed to happen. I think that deadline this year was like on a Monday. I think it was the Thursday before somebody filed a lawsuit and said this coronavirus pandemic has precluded us from signing up, the number of new voters we'd hope to register. So please, federal district court, extend the registration deadline for some period of time. Well, you're butting right up against the deadline as it is. So the folks who are administering the election in Arizona have their set of processes in place and say, okay, based on our anticipated Monday deadline, this is the next sort of dominoes that fall in this string. And so to have the reality of this open litigation, the threat of a district court order saying, you've got to change things, actually is a really big deal and makes it much harder, the closer you get to the deadline for the people who are actually running the elections to try to do their job. Because I do think my sense is that, most of the folks, certainly in our state, the folk when I was in the AG's office here, the folks in our lieutenant governor's office and the county offices who are running these things really try to do a good job. I mean, they're not out to hose anybody or to do anything crazy. They just want to do what's right and just want to follow the law. And it becomes, it can become particularly tricky to try to do that if the law says one thing, but there's a suit pending a couple of days before a deadline that could require you to do something else.
Yeah.
Well,
I agree with that 100%. I think everyone, if you ever come across someone who's an election administration official, you owe them some thanks. It's a very difficult situation, not only because of COVID, but because of rule changes and because of litigation. There's a reason why Pennsylvania, for example, had a quarter of their local election officials just walk off the job in the middle of the year. This is kind of a thankless task, and ultimately, in many cases earned them death threats rather than thanks. So it's a tough job, but I agree, writ large, election, there's always bad apples in every barrel, but election administrators did a fabulous job under difficult circumstances.
Well, okay, so civil litigation can take years. Is there something in the rules that says these cases proceed more quickly when you have one filed 5 days before a deadline? Or do you all just handle it on emergency hearings?
Yeah, I'll defer to Tyler on that. He's a litigator. I'm not. I'm more of a I represent campaigns and work with litigators on these questions. But it's typically happening with a short fuse. You have, unless it's filed well before the election, and you have judges kind of teed up and ready to handle these cases in an expedited manner. You also, I mean, this whole notion of last second filings or changes or things hanging over the election process, that's not a new phenomenon. I mean, I think it's unusual this year in the sense that there's a much greater volume of election changes happening shortly before the election. But I suppose this is a good time to bring up Purcell, which is a doctrine named after a Supreme Court case that basically says, depending on how broadly or narrowly you read it, that there shouldn't be last second changes to election rules shortly before the election. And there are, like I said, there are, you can read that narrowly, you can read it broadly, but that stops most of that makes it less likely that something filed shortly before an election will be successful. And we saw that benefit, I think, the Republican litigants in certain instances and benefit the Democratic litigants in certain instances. There are doctrines built to handle the expedited nature of these types of cases and the fact that they come up kind of late in the game, shortly before the election process is beginning.
Yeah.
Well, actually, go ahead, Tyler.
Sorry, Lori. Yeah, Purcell by itself, to Matt's point, is often sufficient by itself, sufficient reason for a court to deny relief. If you look at the Purcell opinion itself, there's some question that the court said, there may be something to some of these claims, maybe some of these procedures are problematic, but it's just so close to the deadline, and election administrators have such a hard job as it is. We're going to make their life more difficult. We're going to confuse voters. We're going to undermine people's confidence in the election process. So everybody just push pause, right? And, it's not just a sort of week before, there's a lot of cases, it's not just a week before or a month before, depending on the court you're in. Some circuits have different precedent. And I don't think the court's been super clear on this, the Supreme Court, but it can stretch back to, months before the election, just given the reality of how timelines work out and deadlines play out. You may think something is 60 or 90 days out, it's not that big a deal, but when you've got a bunch of things that follow after it, if you change that first one, there can be a lot of chaos that can come from it. So the court, more often than not, has just said, push pause. And, it's important to note, too, I think that's certainly a federal doctrine, applies to federal district courts. So not necessarily to state courts, but there are a lot of state courts that have looked at that and said, yeah, there makes some sense, and looked at that equitable principle and said, we're going to adopt it as well in our courts. So to your earlier question, Lori, most of these, unless there's something specific in state law that might call for some sort of expedited consideration, if they get filed in federal court, they just proceed, most of them, on the typical, temporary restraining order or PI type, framework. So.
Okay. Well, back to Purcell, David Billings comments that the principle that the bigger the change, the closer to the election, the more suspicious the courts are of the revision, seems like a reasonable principle, but is a hard line to draw. The Supreme Court came out sharply divided on application of Purcell in the Wisconsin case, and district courts versus courts of appeals in other cases that didn't get up to the Supreme Court. Where should the line be drawn, and how should the test be applied? Does it matter that we had a once-in-a-century pandemic that was a slow-rolling crisis? So again, depending on how narrowly or broadly you read Purcell, that line could be months or it could be days. What do you think?
Right. Yeah. I guess sort of first reaction to that is Purcell itself predated the pandemic by, the better part, by more than a decade. So I don't think it's necessarily specific to this sort of, longer term type of emergency or, type situation. How long it should be drawn? Look, I mean, this is the issue. Anytime I think you get into something that's inherently an equitable doctrine, you're going to have different views on what's equitable, right? You're going to have different judges that, faced with similar or sometimes identical circumstances, find different reasons to come out different way or different ways. So there's some benefit at that point to having courts of appeals take a look at this, and maybe you can sort of get some consensus on it. But the reality is I don't think there's no good grounds to object to making sure elections run smoothly and fairly. And we need clear rules to do that. And the more time we have, the longer our runway to make sure that's the outcome that we get, the better things are going to be and the more likely it is we achieve that outcome. So the closer you get with each sort of passing day or week or month, as the case may be, to the election, the harder it is for the people on the ground to actually running these things to do it when they have the threat of some sort of order from a court coming that they're going to have to change some particular part of it.
Yeah, I think that's right. It is difficult to determine, when does the starting gun go off, right? When does the period for applying Purcell begin? Both because elections have become elongated over time, right? The timeline for pushing out ballots, especially when you're talking about a vote by mail, a regime that relies heavily on vote by mail, one that has heavy participation in in-person early voting, that starting point isn't November 3rd for this year. That's not what you're looking at. You're looking at when ballots are printed, and other logistical aspects of the rules. And so I think it's been interesting to see academia kind of look at this and over time. And I think as Purcell has become more pervasive, both in federal court and essentially Purcell type doctrines applying in state court, one of the elements of pushback has been that, look, I mean, what we're ultimately through a lawsuit trying to vindicate is an individual right, and a core individual right, the right to vote. And so if an individual's right to participate as a voter is being jeopardized in some fashion, why should we yield to the majority? Why should we take such heavy consideration of what voters generally have at stake? We should be trying to, at all costs, or at least try to balance more equitably the rights and core constitutional rights of an individual. And so there's some sense in academia that it's gone too much the other way, that it's become too broad. But I don't know what the right answer is. I think it's a balancing test, and I think you can point to outlier cases and going both ways and say, no, that's wrong, but I don't know where it is in the middle.
I mean, one punchline to all of this is if there's election law you're looking at right now that you're unhappy with and you want to do something about it for the 22 cycle, you should probably file a lawsuit, this month or next month.
Yeah.
Right?
Yeah, that's an interesting point, because I think, it's not only vindicating the interests of voters generally to have set election rules, but there's also an element, it's kind of related in most litigation, but there's an element of the doctrine of latches in any kind of election case. And in some instances, you do have litigants that, for example, there are a couple of Arizona cases that come immediately to mind after the election, where rules have been in place for years and for election cycle after election cycle. And, what the judge ended up saying to the litigants, the plaintiffs in that case, was, why didn't you bring this up earlier? You had years to bring this up and you're now bringing it to me. Sorry, sat on your rights, latches, it's done. And, that I think is an element of, I guess, a subliminal element to any Purcell application as well.
Okay. So it seemed to me, based upon what I hear from the news, that the 2020 election featured a record volume of litigation. What factors in the increase besides the pandemic?
I think so this is something that's been 20 years in the making, I would say, on some level. I think COVID kind of supercharged everything, but on some level, these are trends that have been building for a long time. And I think both parties have more of an infrastructure of lawyers and resources and organizations built up to litigate on these matters. And then you also have the good government groups that are chiming in and litigating on these points of law. And so I think, aside from the pandemic, I think this is just the continuation of post Bush v. Gore more politicization of, or active litigation involving election rules. People have woken up to the fact that these things can be outcome determinative, therefore are important and should be paid attention to.
Yeah, I think that's right. I think there's, I actually don't think you can think about this last cycle outside of the context of the pandemic. I mean, there would have been a lot of litigation anyway, but there was just no getting around it. Once it hit, there was just going to be issues, right? If you think back to our knowledge really has progressed a substantial amount about the virus itself and the disease and how it works and transmissibility and those sort of things. Back in March last year, right, the whole country was on lockdown. Everybody was shut down. We were all at home. Nobody was going anywhere. There was not the fights. In some places we're seeing now about masks and having that be a viable way to go out and interact in the community. So if the orders, the public health orders are everybody stay home, nobody go anywhere, don't talk to anyone, right? Or else you're going to risk getting this disease. What do you do about in-person voting? What do you do about going to a polling place? Right. You have to, if you want to vote and you've got an election coming up in those circumstances, you have to make some changes. And so if you view that as we got to do it, and we think that the political officers responsible for doing that are not doing it quickly enough or not doing it the way we want to see them do it, your only answer at that point really is litigation. So it was just rampant. It was inextricable.
Okay. What surprised the two of you most about from a legal election administration perspective, this election cycle?
I would say how smoothly election day itself went from an administrative standpoint. I was personally expecting a lot more, I guess, strife and controversy over election day procedures themselves. When you're talking about wearing masks or not to wear masks inside of polling places, or poll observer rules, when the president, for example, advocated that his supporters go out and observe polling places, which in and of itself is fine. But there are procedures surrounding those, where and when and how a person can observe within a polling place without disrupting the process. I was expecting a lot more problems. And not only that, but during the primary was incredibly messy. And I think election administrators, I mean, you will always be able to point to administrative issues, logistical issues in any election, including the 2020 general election. But I think if you look, they climbed the learning curve pretty quickly. If you compare what happened in the primary to what happened in the general, I think it was remarkably successful compared to what happened earlier in the year.
Yeah, I think by and large, that's right. I think one thing I would add to that, I don't know that it was a surprise so much as it was something that sort of struck me as really, really important, is this issue I think we've touched on already a little bit, and that is sort of seeing how state governments responded, and in particular, who in the state government responded, right? This question of it's a classic and sort of quintessential separation of powers question, right? You've got a branch of the government that's assigned to do something, and another branch says, well, actually, I think we're going to do it a different way. The conflict between those two things, between those two branches, is something I think that's really, really important, and that I hope a lot of legislatures are looking at this year and trying to figure out, is the delegation of power we gave to the executive branch, was it the right amount? Was it too much? Were we not clear enough? Do we need to put, sort of more defined guardrails on it to make sure that going forward, the governor doesn't have the authority to do whatever it is he or she wants to do, but has to respect this particular policy choice that we've made as a legislature, which again is expressly within their federal constitutional right to do, right? It's the text of the Constitution itself that tells state legislatures, you guys go do this stuff. So just from a sort of nerdy academic legal theory, point of view, that to me is a really, really interesting issue.
So vote by mail is used much more extensively. I assume that it was used much more extensively in this election cycle than ever before. What are the legal issues that are presented in the vote by mail? Because I voted by mail. I I didn't put it in the mail. I took it to a drop box, but what issues are presented in the vote by mail?
Well, that's one of them. We could probably spend, if we could spend the rest of our hour on this, I think if we wanted to. There's lots of issues, I think, surrounding vote by mail. But one of them, Lori, this is take yours. You talked about you put it in a Dropbox instead of put it in your mailbox someplace. If you're talking about elections and making sure that you only count the votes that are timely cast, how do you know if a ballot's been timely cast if you mail it and there's no postmark on it? One of the things we learned during our litigation is that as a general matter, the United States Postal Service does not put postmarks on postage prepaid envelopes or things like that. They have a different way. There's a barcode at the bottom they use to track that. And the point of a postmark is to invalidate a stamp, really, so that people can't use that same stamp. It's a revenue protection measure. So all of these election parcels are postage prepaid. It says in the United States Postal Service rules, they've got a whole manual that's about election mail. It's, I forget how thick it is. It's been a while since I've looked at it, but it's pretty thick, specifying how things are supposed to be designed and the color on the front of it and what it's supposed to look like and logos and different things. Well, one of the requirements is that it be postage prepaid. So you run into a situation where you're complying with that. You put it into the mail, and as a general matter, the default rule is that piece of mail is not going to be postmarked. Well, if you put it in the if you put it in the mail within a day or two of the election and it shows up with no postmark in it or with no postmark on it, how's the election administrator supposed to know if it was timely mailed or not? So just something as simple as a straight up timeliness question as to, is the ballot valid? Should we count it? Right? That's a pretty big deal.
What do you see, Matt?
There's a host of logistical issues, and as Tyler mentioned, I mean, there's, how broadly should vote by mail applications be sent out? Should they just be on demand? Should they be sent to all voters? Should they be sent to, and for that matter, ballots? Should vote by mail ballots be sent to every voter? Should they just be sent to requesters? You have states making a variety of policy decisions. And I think that caused some confusion. I think especially with some of the rhetoric, there were, basically things that it was alleged in Pennsylvania, for example, that, ballots were sent to every voter, which wasn't the case. I mean, that was done in a couple of states. It was done in Nevada, California, Utah, for example. But I think that caused some, there are a lot of logistical issues whenever you're talking about vote by mail. How do you verify it? What's sufficient? I think the issue that comes to mind, though, for me is how the election was perceived, or the administration of the election was perceived, and the heavy use of vote by mail ballots. Because you have from, for example, just as volume, you're going from about 24 million mail-in ballots in 2016 to about 100 million mail-in ballots in 2020. Exponential increase in volume there, and you can see the complications that it causes in Pennsylvania, for instance. They went from about 300,000 mail-in ballots in 2016 to about 3 million mail-in ballots in 2020. And when you're talking about that type of large-scale adjustment, things that have never been problems before suddenly materialize as big issues. And in Pennsylvania, I think if you watch cable news over the last couple of months, you're very familiar with this. Pennsylvania had an arcane rule that forbade Pennsylvania election officials from starting to process mail-in ballots before the morning of election day. So mail-in ballot has layers to it. You have to get it, verify if that's required under state statute, take out an envelope, and then start to peel back the layers of the ballot. That takes time. And when you're talking about 300,000 ballots out of 6 million, it's not that difficult for election administrators to be able to process mail-in ballots. When you're talking about 3 million ballots, it can cause huge delays in ultimate reporting of results. And I think so that, as well as the fact that we've become divided in not just from Republicans and Democrats, not just become divided in, the types of cars we drive or the types of entertainment we seek, but in the way that we actually cast ballots. That results in these very large swings depending on what type of ballot you're talking about. So it's not just a matter of geography, but you're also, you can expect a Democrat now, they might have been slightly more likely to cast a ballot by mail. In 2020, it was much more likely, a Democratic voter was much more likely to cast a ballot by mail than a Republican voter. And the inverse is also true. And so that led to, when you're talking about processing and reporting of results, these large swings in how they were reported. And I think that's problematic long term. I think we need to make an effort to depoliticize the method of voting. There's no reason why mail-in voting should be more Democratic than Republican, or in-person voting should be more Republican than Democratic. And it does cause, I think for this particular election cycle, it's very difficult for not only election administrators, but media outlets and reporting. I work with NBC quite a bit, and it was there on election night. And as things are coming in, it's just you get Biden batches or blue batches from an otherwise red county, and it was because they were vote by mail ballots. So to the extent there were Democratic votes in a Republican majority county, those were cast by mail, and so it just causes a lot more confusion than is needed, I think.
So Matt, Lori, could I just follow up on that just for a second?
Yep.
I thought it was interesting. I agree with that. I thought it was interesting. I think, Matt, you called it an arcane Pennsylvania rule that didn't let them start opening and counting before Election Day. The policy argument, I think, against that is to say, look, what if you've got a race someplace that's everybody expects to be a really, really tight race, and you come up to Election Day and somehow, state law provides some period of time, pick a number, a week before Election Day, 3 days, whatever it is, where the counties can start opening those ballots and start verifying them and figuring out, getting a running tally of what's up and what the results are. There's some, I think, potential policy concern that somebody could say, well, that information then is going to be out there and knowable somehow by someone. And do we want to create a situation where, in the week or a couple of days building up to the election and what everybody expects to be a close race, we're going to know that whatever candidate in whatever race, we're going to know the results via preliminary results. And so over the last, 7 to 2 to 3 to 4 days before the election, there's an extra push coming from, the other side's supporters to go out and gather whatever kind of ballots you can get. You can imagine some shenanigans that might come from that if people view it as a sort of neck and neck thing. And we already know, right? Somebody's told us, we have the numbers, they're out there, that we could go out and try to do something in response to that. That's the argument, I think, at least one potential policy argument for saying, well, how do we do it? How do we actually manage this? I don't pretend to have the right answer. I just think this is some stuff that I've heard. And it's one of the questions attendant to the one you raised, Lori, about what do we do about this vote by mail stuff? How do we count them? Because to Matt's other point, if you don't do it before then, it drags it out that much longer on the back end.
Well, and I think that's a valid point. And I think what used to be the case that processing would start on or shortly before Election Day for mail-in ballots. And then states have gradually, in lieu of that type of temporal deadline, have started to shift toward penalties for election administrators or any individual that prematurely discloses election results. So maybe there's a different policy choice we could make there, but there still is a policy trade-off. For example, with Michigan, one reason they had a late processing date is under Michigan law, if you file, so let's say I'm a Michigan voter, I decide to mail in my vote, I can subsequently, up until the day before the election, I can subsequently void that submitted mail-in ballot and decide to vote in person. So I can change my vote, right? That's one of the criticisms of vote by mail, is because the voting has to happen so early, it doesn't provide for the fact that there might be late-breaking information that might cause people to change their vote. And if you want to allow that type of flexibility, it almost necessitates that the processing deadline is later. I think what I'm saying is you probably shouldn't have both, right? You have to either limit vote by mail participation as Pennsylvania had in the past and have this later processing deadline, or have an earlier processing deadline and have a broader participation in vote by mail. But I don't think you should have both. I think that's something that Pennsylvania will hopefully look at. I am not one who's ever thought, I think it's easy to have a misconception that election results should be known on election night. I don't think that's the case, but we obviously had a number of states drag things out longer than is needed. And particularly when we're talking about a swing state like Pennsylvania, there's a national interest and audience and pressure that comes to bear on every single one of those decisions. And I think we should take that off the table and move forward for a smoother process.
Yeah. And a related point too, Lori, sorry, just one last thing, if I could. This question, what to do with ballots that get mail-in ballots that get rejected? What kind of cure process does state law provide? Right. Matt talked about, when you mail them in, if you're voting that way, typically you have to sign it or put on, in some states, a voter identification number, some other way or mechanism to let the state know that this voter is who this voter purports to be. Well, what if there's a problem with that process? What if for some reason the signature gets rejected? What if they didn't sign it at all? What if the voter identification number is wrong? Should states provide a period of time after election day for those ballots to be cured? If so, what should that look like? Should you send them a text? Is the county responsible for calling people? Do you send them a letter? How long after the election period or the election day should that period be? Is it enough to get everybody back within a week? Should you give them 3 days? I mean, I don't pretend to have answers to these questions, but these I think are real serious and real important policy questions that a lot of legislatures, if they haven't already grappled with, should be grappling with right now if we're going to stick to this process of having vote by mail be as widespread as it was this last go round.
Okay, we've got about 17 minutes left. I'd like to jump into some thorny issues if we could here. Number one, was it within the vice president's power to disregard the certified elector slate on January 6th? We heard a lot. The vice president can just null the electoral college. Is that possible?
Absolutely not. I think it's. I think you can tell there are only a very limited number of voices advocating for that action. Even those that objected to elector slates weren't going so far as to suggest that the vice president had sole and exclusive power to decide an election, which would be what would happen, or what was being presented as an option there. I think if you look at the text of the Constitution, structure of the Constitution, and the text of existing federal law, it's pretty clear that the vice president has mostly a perfunctory or functionary role in the joint session of Congress that counts electoral college votes. And it would just be, I mean, if you take back even a step back from that, just to think that, the founders, the framers of the Constitution, who had fought a war and risked their lives against the whims of a tyrant, would have just turned around to make, instead of having a kingmaker and the vice president. That would be antithetical to what they stood for. And so I think I don't know how that idea got placed in the president's head at some point, but I think it never was going to happen. It was never possible. The election was lost prior to January 6th. And I think this, most of the time we're not dealing with life and death issues when we're talking about election law. But unfortunately, here we were. And there was a tremendous amount of speculation and a buildup of this unreasonable expectation that the vice president could save the day and unilaterally decide, and that just doesn't match with anything we know about the vice presidency. It's compared to a warm bucket of spit on a regular basis, and there's a reason for that. It's just not that powerful of an office in most instances, and it's not here.
Okay.
Yeah, I agree.
So,
The vice president made the right call.
Yeah, 100%.
President Trump lost nearly all of his post-election cases. Why was that?
So I'll jump in there, I guess, and feel free to chime in, Tyler. But the way that I look at the litigation that unfolded in the 2020 election cycle is you have the pre-election cases. And there's a lot of really interesting, meritorious cases on both sides there where, you are talking about, adjusting election regimes and rules in real time to try to adjust to COVID. And then you have the regular back and forth between Republicans and Democrats. There's a lot of meritorious litigation in the pre-election period. And then you move from phase 1 to phase 2, kind of the immediate post-election period. I think, again, there's a lot of meritorious litigation in that, there were challenges to observational rules, the ability of Republicans, for example, to observe the counting of elections. If you've ever been in the trenches for a Republican candidate like I have, this is a fight. This is a normal fight. I think what ended up happening is there were some flaws in those cases, in that the flaw didn't match the remedy. That's one of the issues. Just because you weren't able to stand within 5 feet, you were told to stand 15 feet apart as opposed to 5 feet apart. Doesn't mean that the election was stolen or that votes should be cast out altogether. That's obviously a very hefty remedy. I also saw a lot of cases that represented a misunderstanding of the election process not by the lawyers so much, but by the affiants, the people who filled out affidavits, not really understanding. And that's very common, by the way. That's something you have to do if you're acting as general counsel for a campaign. You get a lot of complaints and a lot of things that are proposed supposed irregularities, and your job as an election lawyer is to kind of weed those out. And then you have another group of cases that were basically only affected a limited number of ballots and couldn't have been outcome determinative. And so there, like I said, there are a lot of meritorious cases in that phase, but then you have this third phase that I think is incredibly problematic and specious. Arguments were being made all over the place by the likes of Lynn Wood or Sidney Powell or Rudy Giuliani, where it moved from good technical cases and objections to actual procedure into the realm of conspiracy. And it's a most unfortunate development. I'm a Republican lawyer. I have a lot of friends on the Republican side of the election law bar, and none of them would touch these cases because they were so problematic. And I think it's unfortunate that we didn't stop after the second phase of litigation. That's where things should have wrapped up, and we would be in a lot better place as a country if we had.
So how do we increase faith in the election process after this last cycle?
Go ahead, Tyler.
I was going to piggyback on you here, Matt. That's what you had to say. So I mean, as a general matter, look, to picking up on Matt's earlier point, this question about process, right? I think process matters a lot. I think if you've got in this realm in particular, if you've got a set of rules that have been democratically put in place, unless there's an obvious constitutional problem with them, they should be followed, right? That's one of the inherent fundamental bargains of our democracy. If you don't like the law, there are certainly ways to change it. You can pressure your legislators, and if they don't listen to you, that you can vote the bums out and put new people in and have them change the law that way, right? So doing what we can, I think, to make sure that people's voices are heard and that the law reflects the will of the people on things like the stuff we've talked about with mail-in ballots or other types of questions, I think is going to go a long way to try to hopefully restore some faith in the way our election works.
Yeah, I 100% agree. And I think there are a lot of places where we can improve election processes and make things more transparent. I think with that said, in my view, the problem with the 2020 election really has not been a process failure. I think it has been a rhetoric failure. And in the past, we've had losing candidates. It's the most difficult thing to do in the world. If you've been with a candidate on election night, you understand how crushed they are, how difficult emotionally it is to be very publicly rejected. And it takes some guts to get up and say, I lost, or concede to your opponent. I think the main problem here, although process can be improved, you look at a circumstance like Georgia, where there was an initial election run by Republican election officials. Biden won, and it was followed by a manual audit of all the ballots. It was then followed by a machine recount, as well as a review of signatures by the Georgia Bureau of Investigation in the most Democratic county, or one of the most Democratic counties in the state. Even after that, there is a spinning of conspiracy theories about what happened with the machines, or various aspects. It's just full of conspiratorial, incorrect information. And I hope in the future, one of the takeaways is not only process improvements, but a drastic change back to our traditional norms on what's a real problem and what's not. This is much more. This has been a much more divisive election than even Florida in 2000, and none of the problems or irregularities came even close to what we saw in Florida in 2000. And I think that just means we need to change the way that we're talking about these issues.
So I guess that leads to my next question, and this is pretty basic.
Sorry, could I just check one thing there?
Yeah.
Somebody sent me an article, a link to an article this morning that I pulled up and read. And let me just find it. I got it up here. Let me read the last, this is the last paragraph of this article. If you don't want to call it being the election, if you don't want to call the election stolen, I'd like to hear your suggestion for a more appropriate word for what just happened. So I won't make you guess as to who was saying that or what they were saying it about, but I'll just tell you, it was a link to a 2016 Washington Post op-ed piece. The title, "The 2016 election was stolen, got a nicer way to say that." This is from Tom Tolles, the editorial cartoonist at the Washington Post. So I totally agree with Matt that the rhetoric has been an issue, certainly this go round, but it hasn't just been this go round, right? This has been an issue we've been facing for at least the last 4 years.
That's a good point. And I guess my attention to it has been drawn more because I sit on the Republican side, and I think that the Democrats should have ostracized Barbara Boxer after she objected in 2005 to the Electoral College slate in Ohio. They should have ostracized Stacey Abrams after she said the election was stolen without proof in her Georgia gubernatorial race. But it has slowly snowballed, and I've been disappointed to see my fellow Republicans very much not only follow that track, but also extend that type of rhetoric. And we do need to walk that back. It's very damaging. And you can see for the first time since the Civil War, we have not had a peaceful transition of power.
Yeah, this is, to be clear, I don't mean this is not sort of whataboutism, right? I'm not.
You're absolutely right.
I'm not trying to go
100% agreement.
It's a question, right? I think you're right. The point is accurate. The point is correct. And who's gonna rise to the occasion? I think it's an important question.
Hopefully everybody does.
Yep.
So I guess what I'm hearing from the two of you is, notwithstanding all of the rhetoric, there was no widespread fraud in the voting. Is that what I'm understanding from you, Matt?
Absolutely not. Yeah, that there was no widespread fraud. There are always irregularities in any election. But if your standard is perfection, what you're really saying is that there can never be a free and fair election, because there will always be a handful of individuals who will engage in some limited misconduct or do something negligent with respect to handling ballots, et cetera. And so it's a little bit messy sometimes when you look under the hood, but it's a different order of magnitude to say that an election was stolen across multiple states, which would represent the most extensive crime in arguably the biggest crime in United States history. That's obviously a different thing than just saying we didn't get it right in a few places, let's tighten it up moving forward.
So in terms of the rhetoric, would it help if we said, or not we, someone in a position of authority said, yes, there are irregularities, but it doesn't rise to any level that would overturn an election, instead of saying there's no fraud, there's no fraud, there's no fraud. Because I think the more we hear there's no fraud, the more suspicious people get. And if we could change that and say, yes, there are irregularities, but they are so minute that it really doesn't matter. What do you think about changing that sort of way we talk about it?
Maybe, yeah. I mean, look, building up to the election, it's almost like you could track in certain media sources, right? There was like an automatic insert key for the phrase "no widespread evidence of fraud," right? It seemed to show up in almost every report that I read from some of the more traditional newspapers. And yet at the same time, I went back and Googled it again this morning and found it again. The New York Post ran a piece back in August talking, it was confessions of an unnamed, they didn't identify him, but somebody who said that he had spent a lifetime fixing mail-in ballot elections in New Jersey. He said he'd worked on elections all the way from city council races all the way up to U.S. Senate races. So I think it's out there, and it's an important thing to remember when states, this is one thing that I think that comes up that I don't know if we touched on necessarily yet. State legislatures, and the Supreme Court's been pretty clear about this, state legislatures do not have to wait until fraud occurs to be able to respond to it, right? They have the ability when they're setting policy and deciding what election laws to have, to anticipate it, to try to stave it off, and to put things in place that will keep the election fair and honest. So to have somebody make the argument that, no, you can't, if all you're doing is voter suppression, if you're trying to strengthen the integrity of your election, unless there's been some evidence of it in your own state, is just not accurate. It's not an accurate recitation of what the Supreme Court has said. But to your point, if there's not enough irregularity to change the outcome of the election, that's something people have to keep in mind when they're bringing these types of suits.
Yeah, there are always irregularities and always fraud. And so it is inaccurate to say no fraud, no fraud. I think where we've gotten, we're kind of talking, I think the two sides are kind of talking past each other in that, what I think everybody's really saying is the Democrats are saying, well, there's some fraud. They're loath to acknowledge that there's some fraud because that'll get taken out of proportion. And then the Republicans are seeing some sort of irregularities and at least want that acknowledged. And I think the whole area just really needs it's at the core of politics, but it hasn't always been politicized. And I think if you look at Utah, for example, Utah is in many ways a model where everybody feels like the system is secure, but it's incredibly accessible to a broad number of people. And a lot of people voted in Utah this last cycle, and that should be the goal of everyone, not voter suppression, not, opening things up so people can cheat, but moving hand in hand of expanding accessibility and ensuring security at the same time.
Well said.
So one final question, we're out of time, but do you think there are things we can learn from other democratic countries that don't seem to have these issues?
I wouldn't pretend to be familiar enough with the way they do it in other countries to know if there's anything we can use here or not. I think we've identified, hopefully today, some things we can work on internally ourselves. Beyond that, what other people do, I'm not educated enough to be able to comment.
So I think the issue with that, certainly there are some process best practices we should be implementing, especially if you're talking about election adjudication and such. But I think our system is so unique. Usually when people are pointing in election administration to other countries, they're often calling for the nationalization of an election process, making things uniform so that they there's one set of rules. And as I said, I think there's not, our election system and our system of government is somewhat unique. And so I'm sure there are a number of policies and procedures we could take out of other playbooks, but nothing structural and systemic is in order, I don't think.
Great. Well, we are out of time. We have had some questions that haven't been answered. I would like, we will try to reserve those questions and answer those that we can by email. But I want to thank the two of you for participating today. It was hugely informative and helpful, and answered a lot of questions for me that I've had over this election cycle. I've just decided to quit watching the news so I can sleep at night. But this has been very helpful. So thank you very much. And thanks to all of you that were with us during this presentation. And I hope to see you at our next. Thank you again.